Good afternoon, everyone, and welcome to the Hamilton Brook Smith Reynolds webcast, Protecting Brands for Virtual Currencies. My name is John Dupre. I'm a principal in the firm. With me here today is Josh Matloff, one of our associates. Before we begin, I'd like to tell you a little bit about our firm. Our firm is an intellectual property firm. We protect the rights of clients in patents, trademarks, copyrights, trade secrets, and similar types of rights. That's the focus of our firm. Essentially, it's all we do. We have two offices, one in Boston in the Seaport Innovation District, and another office in Concord, Mass, in the Route 128 Technology Corridor. Our firm handles a number of technology specialties. In fact, in my view, we handle everyone, including the traditional areas and cutting-edge technologies. And we're one of the leading firms in handling financial, virtual currency, and blockchain patents and trademarks. As I said, I'm a principal of the firm. The focus of my work is intellectual property litigation, as well as trademark protection and prosecution. I worked in all areas of technology for all types of companies, as wide as pharmaceuticals, electronics, and telecommunications, as well as consumer products and services. And we are always getting involved in cutting-edge technology, such as blockchain and cryptocurrency, and that's the focus of our talk today. And I'd like to introduce Josh Matloff.
Thank you, John. As John said, I'm an associate here at Hamilton Brook Smith Reynolds. I'm a registered patent attorney with 8 years of experience in both trademark and patent law. And I've worked with various companies to help them secure their brands through trademark registrations. And I'm really happy to talk about this exciting topic today with you, John, on this webcast.
Thank you, Josh. And before we begin, I think we'd like to address the primary question in all forms of protecting intellectual property. The primary question is, why bother? Why should you be interested in trademarks? Why are they important? What makes a difference in the marketplace if you have trademarks or if you don't have trademarks? And this slide addresses that. Before going further, I also want to make sure that everyone is aware that there is a question screen on your computer. If you have questions about any of the topics we covered today, please feel free to send the question in to us. We will address them as we go along, and we will have a short question and answer period at the end. But with that, continuing on the question of why, is you really want to establish an exclusive market position, both in the eyes of your customers, in the eyes of your competitors, and you want to have a position in which you are the only company that can use that trademark or similar trademarks that are close enough to cause confusion. If you have that market position, you're going to be able to keep your products and services separate from competing products and services in the minds of consumers. And if you have trademarks and you're in a position where you need to raise money or bring in partners to make your business go, the existence of registered trademarks gives you market value in the eyes of investors, venture capitalists, bankers, or anyone else who wants to bankroll your business and allow you to move from concept to implementation to success in the marketplace. And once you have those trademarks in the marketplace, they start to represent a level of goodwill and quality. What happens with a product like a virtual currency or cryptocurrency is that people in the industry or buyers of cryptocurrency start to understand what the various cryptocurrencies are, and how they distinguish them are based on the names of the cryptocurrencies. And certain quality or characteristics of each of those are represented by the trademarks, and they really become a shorthand way of people understanding what they're getting. And when you're in the marketplace and trying to get into position where someone makes an informed and quick purchasing decision of that particular currency, the brand name is the way to send that message early. In addition, if you have the mark registered, it can be used for defensive purposes. And by that I mean, if you have the trademark and you're using it, and somebody else approaches you and tries to interfere with your use, your existence of a registered trademark can give you the right to fend off all those attackers. And you would be able to continue to use your mark despite someone coming against you. So the defensive purpose is very important when you're considering the brand to adopt and to position yourself to maintain that exclusive position in the marketplace. Our agenda today, and these are the topics we hope to cover. We're going to begin by having a discussion of what is a virtual currency or cryptocurrency. We're going to talk on a very high level about what a trademark is, what types of options are available for a trademark. The question is, can virtual currency be trademarked? Because many of the initial virtual currency names were not trademarked and not protected and actually have gone to a position in the marketplace where they're available for everybody to use because no trademark protection was sought. We're going to cover a little bit about the form that trademarks can take. The sky's the limit here. You may be surprised on some of the options that are available. We're going to focus in on our discussion on 4 of the forms that are most prevalent in this area. But if you are creative enough, you can get into some of the other areas as we'll discuss. We're then going to talk about how to select good trademarks. There actually is a distinction you will find. If you select a weak trademark, it's hard to register, hard to enforce, and hard to defend. But if you select a really strong trademark, and Josh is going to talk about strong trademarks, you're going to be in a position to register it easy and at a relatively inexpensive cost, and also be in a position, a strong position, if you have to pursue someone else, whether it be in a contested matter in the trademark office or in the federal court. We're going to talk a bit about how you file for a trademark application to cover products in this industry, when and how you use trademark notice or our circle. It's one of the most frequent questions we get regardless of the industry we're in. And then a little bit at the end about steps to take to police against infringers and some things to keep in mind when you're ready to pursue them. And with that, I'll turn it over to Josh, who's going to cover the topic of what is a virtual currency.
Thank you, John. Virtual currency can describe various forms of digital money that can, but do not have to, use blockchain principles. These currencies can be decentralized completely, like Bitcoin, or more centralized, like virtual currencies such as Ripple. Even before the blockchain was invented, however, there were other centralized virtual currencies in other contexts, such as within video games. Example of games, currencies within games are Linden dollars in the Second Life virtual world video game and World of Warcraft tokens within that respective game. These are generally not backed by a bank or country because the blockchain is a decentralized concept where the currency verifies itself. And that's where a lot of people derive its value from, the decentralized nature and self-verifying nature of the currency. And therefore, the value of the virtual currency is really derived from the market and the perception of the currency itself. And while the currency is sort of, as we say, self-verifying by the blockchain, there still could be bad actors that purport to hold out a counterfeit currency. And while a savvy internet or technology user could distinguish it via blockchain principles, the owner of or the creator of a virtual currency may want to also have protection to prevent counterfeit currencies that are created to dupe less savvy users. That's why if you are creating a virtual currency, we would recommend that you would want to be able to protect it from uses that confuse consumers and weaken its market value. In a tangential field, online exchanges and other services facilitate virtual currency transactions, and these entities should also consider trademark protection for their names for similar reasons. Now, we've talked a lot about virtual currency, but what is a trademark? The definition of a trademark is a name, slogan, or symbol that's adopted and used by a company to first identify its products and services, and second, to distinguish those products and services from those of others. The mark can signify the source of the products or services and also indicate the quality level of the products and services. Stated another way, the value of the mark is the mental association that consumers have with this name, term, slogan, or symbol, and the product it's associated with. Being the owner of a registered trademark allows you to police others attempting to use the same mark to confuse consumers. Now that we've talked about what a virtual currency is and what a trademark is, let's talk about whether a virtual currency can be trademarked. The answer is yes, because there are already current trademark registrations, and we're going to go over several examples of cryptocurrencies and virtual currencies that have been registered. In addition, just last week, the U.S. Commodities Futures Trading Commission stated that virtual currencies fall within the definition of goods and articles that it can regulate. And while a parallel field of law, this is another example that shows that names of virtual currencies can be protected with trademarks, which, as you remember from the previous slides, protects products and services. Now, what are the penalties for counterfeit currency that are currently available? We all know that counterfeiting US dollars is illegal, and that's outlined by the statute, and the section is right here, 35 U.S.C. 470 all the way to 514. What about specialty coins and metals that are privately issued? One example of this is the Krugerrand. The Krugerrand is a specialty brand of gold coin that really signify a high quality of the source of the coin, and they are branded with the specific name Krugerrand. Krugerrand has registered for a civil trademark in the United States, and this trademark allows Krugerrand, the company, to prevent others from issuing coins with its specific mark on them. And this is one way that they can use to prevent others from issuing gold coins in their name. Virtual currency is actually very similar in this regard. Trademarks can prevent other parties from using a brand name of an already existing cryptocurrency. And this allows the creator of the cryptocurrency to police bad actors that are trying to devalue the brand name. In addition, by acquiring trademark protection, certain criminal penalties can be applied to counterfeiters, including fines and prison times based on the Trademark Counterfeiting Act of 1984. And now John's going to talk about a few examples of forms that trademarks can take, including some cryptocurrency examples.
Thank you, Josh. And before we go on, I just want to go back to the definition of what a trademark is. First line, name, term, slogan, or symbol. Pretty broad. A symbol can be almost anything. And as you'll see, some of the options for trademarks are pretty creative. So this is just a summary of some of the types of formats that trademarks can take. Most of the trademarks in this area are in the top several listings. The bottom three, we haven't been able to find one in this area, and it's probably unlikely that it's relevant. But we'll go through these examples, and you can see some of the options that are available. And the primary form of trademarks and the primary form in cryptocurrency are words. And here's just a couple of examples. Ethereum and Zcash, registered trademarks covering services offered under these brands. This is the Ethereum registration. It covers the computer software platform. And it's broadly listed to cover applications in cryptocurrency and also in virtual currency applications. Slogans are also very popular in these types of products. Financial services, everyone has seen the ad, "What's in your wallet?" That slogan is certainly a strong brand name. Runs on Ripple is one that I believe has been filed very recently, just within the last month, but it shows that there's an established cryptocurrency that's trying to establish not only its position in the marketplace, but the brands that it offers its products under. If they register runs on Ripple, they may actually be able to prevent other people from doing runs on marks. So it could be quite valuable in the marketplace. And this is just a copy of Capital One's "What's in Your Wallet?" Credit card services, not exactly in the field of cryptocurrency, but it's in the same class, class 36, which is where most of the financial services are registered. Another common form of trademark are letters. Ripple, who is the one that's one of the most active companies in cryptocurrency in terms of registering their marks, has registered XRP, which I understand is their trading symbol, and their registration here. You will note that this was an application that was filed by another company. Ripple acquired the marks from that other company and is now the record owner. But when we put up a copy of the registration certificate, it still identifies the record owner. But this, financial services for providing secure payment options, that's everybody's understanding of how a cryptocurrency works. And again, these letters are very strong as a trademark and an option depending on what you decide you want to put forth as your brand in the marketplace. Another common form is a set of numbers. This is very common in lots of industries. We were not able to find one in this industry, but there's no reason why it couldn't. You could actually adopt something like, say, 24K. It gives a suggestion that you're at a 24 karat. And you know, maybe there's a little bit of a suggestion of high level of quality. It could operate as a very good trademark in this field. But something like that is available, and if you decide that that's the way you want to brand your company, you can proceed. 747, obviously a well-known trademark by Boeing. There's lots of others in other markets. A lot of consumer markets have trademarks that include numbers. Another frequent form of trademark is in logos, logo designs. They're marks that actually don't have any words, letters, or numbers at all. It's just a unique design. Ripple has one registered here, a unique design, 3 circles bound in the middle. Any format like that, when somebody sees this brand in connection with the promotion of a product and promotion of cryptocurrency, then everyone recognizes this as the Ripple product. And again, this is software as a service, slightly different description of services depending on how it's being offered for providing electronic financial platform. One of the key things when these applications are being filed is to make sure you're properly identifying the nature of the service being offered. If in your original application you don't do the original or the proper identification or the proper claim of use, you could actually end up with an application that's invalid. So you need to be very careful when you start the application process to make sure you're covering the services that are actually being offered. And just to go on to show you some of the other forms that trademarks can take, you can have a color, again, not really all that relevant for purposes of cryptocurrency, but some well-known color marks are the color pink for insulation by Owens Corning, and UPS's color brown for its trucks. Shapes can take the place of containers for products. Frequently, there are registrations for bottle designs, particularly if the bottle designs are unique and distinctive. Sounds also can be registered, again, very infrequently, but there are some certainly well-known ones. The NBC chimes, the Intel tones, and ESPN Sports Center. So when you hear dot, 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 you know they're talking about ESPN. But more recently, one of the most creative registrations, and it actually issued earlier this year, is for smell, and it's for the smell of Play-Doh. Pretty creative filing, and just to give you a feel for what these types of trademarks look like, this is Owens Corning registration for the color pink. It's just a piece of insulation that's lined for the color pink, and that's the only thing they cover. Nothing to do with the shape, nothing to do with any words, it's just the color. Bottle design, this is an example of Black Daniel's bottle. You can see on the trademark registration, which is the line drawing below United States of America. That's what the registration looks like. It covers a particular design of a bottle, and the two designs are up there just because there actually is some dispute between the two, and the question is, does the one on the right create likelihood of confusion just based on bottle design with the Jack Daniel's bottle? And this is the NBC chime. The mark comprises the musical notes, G, E, C, played on chimes. So it's sort of interesting when you get into these, I'll call them odd types of marks, how you have to describe the brand. This is the one I just talked about, the one that issued earlier this year in May of 2018, non-visual Play-Doh scent. I've had a hard time trying to figure out how this can apply to cryptocurrency. Maybe somebody can come up with something that's the smell of money, but it's pretty hard. But this mark it's described as the scent of a sweet, slightly musky vanilla fragrance with slight overtones of cherry combined with the smell of a salted wheat-based dough. So I don't know how you can imagine what that really is. Everybody knows what Play-Doh smells like, but I'm not sure you'd be able to tell whether there is another infringer of that. But anyway, it just gives you the idea that the sky's the limit when you're trying to get trademark protection in terms of the design. And you can have combinations of these. You can have a logo design combined with a word. You can have numbers combined with words. And there are lots of brands that are combinations. And with that, I'm going to turn it back over to Josh. He's going to cover how you can select good trademarks and avoid bad ones.
Thanks, John. Before we move on, I just wanted to give a quick reminder to submit any questions that you may have in the question and answer box. We already have a few submitted, but if you have any questions as we move on through the presentation, feel free to type those in and we will try to get to them at the end of the webcast. So now, how can you select good trademarks? We referenced this earlier. And how we normally advise our clients is we talk about these four categories on the slide here And they're listed in this order because they are listed from least protectable to most protectable, where the least protectable is generic. Descriptive is slightly more protectable but has some issues. Suggestive is better than descriptive, and distinctive terms are really the best terms that you want to aim for in a trademark. So we're going to go through each of these categories with a couple of examples of marks in the currency, Bitcoin, virtual currency area. And first, we're going to start with generic terms. So generic terms are not protectable. And examples of these in the currency field are coin or token. The reason that they are not protectable is because they identify the products themselves rather than the source of them. If a trademark for coin were to be allowed, it would not help consumers identify the source of the product, and it would just give somebody the exclusive market position to prevent all coin companies to prevent using coin. And the Trademark Office simply does not allow registrations on terms like these. Token is another similar term used in the blockchain field to denote units of currency, and that similarly is a generic term that is not protectable. Next, we have descriptive terms. Descriptive terms identify characteristics of the product being sold, and but protection for such marks can only be acquired if the mark is said to have acquired distinctiveness for consumers. So this only happens when the mark is so prominent that consumers recognize the mark or the brand rather than the product. Outside of virtual currency, a good example of this might be American Airlines, where it describes exactly what the product of the mark is. It's an American airline. It's descriptive. However, since American Airlines has been around for so long that it has acquired distinctiveness, and therefore it is allowed to have trademark protection for that term. Similarly, Bitcoin and blockchain are currently considered descriptive terms by the USPTO, and people have attempted to get protection on Bitcoin and blockchain unsuccessfully in the financial services field because the Patent Office has ruled them to be distinctive, or descriptive, rather. Bitcoin itself is an interesting example because, as many of you may know, when it was invented, it was created by an anonymous user who chose not to file for trademark protection at the time, and he just let the term grow on its own. And that was his strategy. Because there was no protection sought, Bitcoin, as it grew, became used by the public to describe digital currency in many instances. And the Patent Office, the Patent and Trademark Office has found various instances of Bitcoin being a substitute for virtual currency in general. And that is why the Patent Office rules this to be a descriptive term that really cannot be protected at this point. Blockchain is similar. There may have been a point when blockchain technology was first invented that if the inventor had, or the creator had filed for a trademark application on it at that time, it may have been suggestive or it could have acquired distinctiveness, but at this point it is a descriptive term, and it would be hard to get a blockchain patent on a blockchain technology.
Yeah, Josh, I actually think that Bitcoin is really an interesting example. When it was originally adopted, it could have been on the road to be a very strong trademark. The adopter and the first user of the service, however, there was another road available. They wanted to get the use out there broadly. So you could go down the trademark path and try to create a brand unique, limited to you, or you can go down, I'll call it the genericide path, where you take a descriptive term and get it to the point where it's broadly used but not protected. And I think Bitcoin is one that took the genericide path. And now, as you said, without the trademark protection, Bitcoin can be used by anyone who offers a product or a service associated with Bitcoin.
Thanks, John, and I think that's absolutely correct. It's a very interesting story of the path it took in becoming a descriptive term that's very hard to get trademark protection on. Next, we're going to talk about suggestive terms. Actually, excuse me. Before we discuss suggestive terms, we're going to show a quick example. As I mentioned before, this is a registered trademark for Bitcoin bitmap, but you'll see highlighted in yellow at the bottom, the Patent Office says no claim is made to the right to use Bitcoin apart from the mark as shown. And that basically means that the owner of this trademark can prevent people from using this combination, but they cannot prevent people from using Bitcoin on Bitcoin alone in the field of internet advertising services. So this is an example of the Patent Office limiting the use of Bitcoin becoming trademarkable on its own. And now we'll talk about suggestive terms. Suggestive terms are terms that hint at the type of product that is associated with the mark, but don't quite describe it like the descriptive terms we talked about above. And so examples of this are first Monero. Monero is a digital currency, and there actually is not a registered trademark or application even on this mark, but we're bringing it up because it's such an interesting example. It seems to be a portmanteau, a combination of money and dinero, which is the Spanish word for money. So I think when consumers look at Monero, they think money, they think currency. There is a slight mental association with that field, but since it's this combination and it's not a real word, it probably would be a suggestive term, that it really just suggests something in the currency field, but it doesn't describe it exactly. And that's why it would be a suggestive term, and likely we think the Trademark Office would accept a trademark and allow that to registration. A next example of an actual registered trademark on a virtual currency is Zcash. It has cash right in the name, so that's the suggestion right there, but the Z in front of it makes it a little more suggestive because what is Zcash is supposed to cash? It's hinting at the product, but not but it really is an identification of the source through its suggestiveness. And the Patent Office has allowed multiple registered trademark applications on the trademark Zcash. Last is the term Coinbase, which is for a digital currency exchange rather than a digital currency. And Coinbase seems to be suggestive because, it's a base for coins. This is another combination of words that isn't a word on its own, but hints that, a base for coins could be a place where you might trade currency, digital currency, coins, and that's why it could be a suggestive mark, and the Trademark Office has allowed registered trademarks in this name.
Josh, there's a number of interesting examples there. When you go back, you see both Zcash and Coinbase have generic terms in them. So when you combine the generic term with something else, and again, there's a combination with a letter, another combination with another word, you can get really strong protectable trademarks. So if you're starting out with a generic term and you want to get something that's protectable, go this route of combining it with something else that gives you the level to take it out of the generic sphere.
That's exactly right. So now that we've gone over some suggestive terms, let's see what distinctive terms are. And as we've said before, these are really the best trademarks that you want to, when we advise our clients on what marks to select, we tell them to try to get distinctive terms. Distinctive terms are broken down into two categories. First are terms used in a new context. The example we have here is Ripple. Ripple is a digital currency that, but it uses the term Ripple, which is an actual word. But Ripple doesn't describe money. It doesn't describe financial services. It may describe a ripple in a wave in water. But when you think of Ripple, you would never think digital currency except for that this brand exists. So that mental association of Ripple to digital currency is very strong because it's so far removed from the product. It's kind of counterintuitive. Another example of this is Apple Computer. So Apple would not be a registerable trademark for an Apple farm because you could not get the mark Apple to sell apples. But when you're using Apple to describe computers, iPhones, iPads, that's where you get protection because the fruit apple is so far away from computers and technology that's actually a really, really strong mark. So terms used in a new context are one great category of marks that you can use. So that's one path, is to look at terms that are in left field from your field, and specifically here, virtual currency. So look at terms that have nothing to do with finance, nothing to do with the blockchain, Bitcoin, or technology in general. And you can find a whole dictionary full of words that could be terms used in new contexts. In addition, there are coined terms, and these are terms that are entirely made up. And the example we have here is Ethereum. Ethereum is not an actual word. It doesn't seem to be a combination of two words. To the extent it may be from a word, it's from the word ether, which again is not really in the context of virtual currencies. So a coin term, a totally made up term, is another great way to go for coming up with a virtual currency name. And that's what we recommend for clients, is that first, try to come up with a distinctive term, such as a term in a new context or coin terms, or we recommend, if you can't do that, at least have a suggestive term and try to avoid these generic and descriptive terms if at all possible. And now I think John is going to talk about some searching strategies.
Thank you, Josh. One of the things to think about here, okay, you've gone through the exercise of deciding that you need to register your trademark, you've selected the various forms, and you've selected really strong trademarks, and you're ready to go. And now the question is, do you start to use it? And our advice is you better make sure it's available. Because if you start to use it without making sure it's available, you could get into a situation where you invest a lot of time, money, marketing dollars, internet space, websites, using a brand, only to find out that you have to change. So it's really critical once you adopt a mark, and you've adopted a mark that's strong and protectable and registrable, that it's available for use. And here's some of the areas in which you should be checking. First of all, check industry resources. No one has a better knowledge of what's in the industry than somebody who's there. If you know of a brand that's close to one you're adopting, bring it to our attention. We'll try to make sure you're clear of that. You should also do an internet search. Make sure, for instance, the domain name is available. Many times they are for a relatively reasonable price if you acquire it early in the process. You can also do an issue of doing a trademark search at the trademark office. We have a very skilled trademark paralegal here who does this really efficiently. He knows how to access it. We have access to certain databases that make it really critical to do the initial screen. And all of that is before you actually get to the point of deciding you're going to go forward. You do all of the first 3 bullet points. But then again, you get to the point where you're about to say, I'm going to invest tens of thousands, if not more, in actually getting this service off the ground and being offered. You really should do a full trademark search. We use a search service. They do a very, very thorough report at a relatively reasonable price, much more reasonable than anyone could duplicate if they tried to do it themselves. We do the review of the search report and provide a clearance opinion that then puts you in a position that you understand you're going forward in good faith without infringing somebody else's mark, and you have a mark that you're going to be able to register, and if there are infringers, you're going to be able to enforce. So if you're in the position where you're about to offer cryptocurrency or something similar to that in the marketplace, you really should spend the time and effort to make sure that you've got something that you're going to go forward with and not have brand issues at some point later on. And if it's clear, what do you do next? And we highly recommend that you file an application for registration. And this is a somewhat complicated issue because there's a bit of an art at identifying the services being offered and understanding what is use and what you can rely on for use. We've actually been in situations in which people have filed applications on their own only to find out they're being rejected and the application is in a particular condition that can't be protected, so it has to be abandoned and you refile. So you want to make sure if you're going down the road of protection that you're going down the road in the right way. And we did get a question that is sort of related to this. The question is, how many, are there any trademark differences between cryptocurrency and utility tokens or other forms of crypto assets? And it's sort of an interesting question because you would think, okay, I've got my brand and I'm offering the cryptocurrency, or I'm offering tokens, or I'm offering other crypto assets. I'm just going to go ahead and register it. You better make sure that the services and the goods in your registration properly identify what you're offering. So the question is, there's no real difference in terms of the types of brands that you can use or a strong trademark versus a bad trademark for each of these items, but the wrinkle comes in when you're actually filing the application and properly identifying what you're covering and whether you can file based on actual use or intent to use. So, so there is a difference because you have to make sure that when you do your application, you're properly identifying what the company is providing. And again, you want to file as early as possible to avoid others from filing before you. The key in trademarks, if 2 entities have the similar trademark, who gets the right to continue to use? You can't have 2 people using the same brand in the same industry because then what happens is there'll be consumer confusion. When consumers see that brand in use, they won't know which company is actually providing what they're getting. And they could be getting something different. Company A may provide the cryptocurrency having certain characteristics or a token with certain characteristics, and company B using the same name may provide something different, something better, or it could be worse. So that's why you can really only have 1 entity out there in a particular market using a brand. So the question then becomes, if you have 2, who wins? And the answer is whoever is first. The first to use or the first to file is the one who uses. So if you have use out there, that's important. But if this is a relatively complicated business to get into and to set up and to actually start offering this product in commerce, you may want to consider filing based on intent to use. That would give you an earlier date. If you file your intent to use application because you have a bona fide intent that you're going to offer that particular cryptocurrency in commerce, then the date of your filing is the date of priority you have against other users. So if other people start to use your brand on cryptocurrency after your intent to use date, but before your actual use, you win because your filing date gives you the priority. So that's really critical. So you need to file as early as possible. If you make the decision, and we recommend that you should, that you want to have your brand uniquely identify what you're offering. So what do you need when you're filing an application? You need to specify the mark, identify it clearly, identify the nature of the services being provided. This is, again, where we would have a discussion with you about what you're really providing to the customers and make sure that you're actually properly identifying the services that are either currently being offered or intended to be offering. And then you pay the filing fee for each class of services. Most of the time, if it's a clear financial service, it'll fall in class 36. That's where most financial services is. But you saw there was one registration where it was platform as a service. That fell into class 42. And there are certain software products that could fall into class 9. So the filing fee is dependent on the nature of the goods and services and the number of classes you have. And obviously, the company, it would be the applicant. It generally is not filed in the name of the president or even the owner of the company. The company itself would be the applicant. And once the application is filed, just to give you an idea, the U.S. Patent and Trademark Office has really sped up its examination. Everything is filed electronically. All communications with examiners are done electronically. Currently, we're seeing office actions within 3 to 4 months after the original filing. The office action may raise questions either with the description of your goods and services or questions of potential conflicts with other marks, or even questions about whether the mark is actually registrable because it may be descriptive or generic as opposed to suggestive. So those are issues that are dealt with. If you do a better job of preparing the application initially, you'll avoid a lot of these issues. And if you've done the search with the clearance opinion from counsel, you virtually always avoid the issue of conflict with another party. So if you have a clean application, it gets approved and published. There's a 30-day opposition period where interested third parties can oppose. So if you've done a search and you think your mark is clear, but somebody else thinks you're going to be confusing with them, they could file an opposition. We actually represent a number of applicants in oppositions defending their application, as well as opposers who are trying to prevent someone else from registering a mark. If it's very clean, you start with the original application. That's got no problems, approved by the examiner right away. You could actually get your registration in about 8 to 10 months. That's very fast. And once you have your registration, you're then in a position to take advantages of all those benefits that we identified early on of why to proceed. And here we're going to talk a little bit about trademark use. Use in a trademark sense is one of the most interesting words because use doesn't mean use in a dictionary standpoint. It has to be used in a particular context. And here I'll turn it back to Josh.
Thank you, John. So virtual currencies that are released without restrictions on the internet should be considered use of the trademark. Usually products that are released on the internet are considered having a nationwide use in the U.S. So that would be considered use. But this is an important time to bring up that registering your trademark also gives constructive use across the United States. So if there's any uncertainty, you can register, or we really recommend that our clients register in all fields, because all fields of technology and products, that once you register your product at the Patent and Trademark Office, that filing date is your constructive use date across the whole country. So if there were any doubt, registration counts as trademark use and really establishes that early priority date, which, as John discussed earlier, that's really important to have when there's a possible other user that could be a prior user in this field. So goods must be marked on the website, and there is no use with currencies if the trademark appears only on your promotional materials or advertisements.
Thank you, Josh. I just want to briefly talk about trademark notice. We get a lot of questions about them, about the use of TM versus our circle. Basically, you can use TM whenever you want. The mark does not have to be registered, or application could be pending. Our circle is much more limited. Can only be used when something is registered and only used in connection with the goods covered by the registration. It's relatively straightforward, and hopefully, if anybody has any questions on this type of issue, we certainly can advise.
Thank you, John. So now we're going to talk about what we advise to our clients on the steps that they should take to police their rights effectively. And this kind of is with an eye on what happens when you have your name or your brand and you have found out that there could be another user of that name out there somewhere else in the country or in the world. And the first step is to register your trademarks if you haven't already. And this is so important. As we talked about earlier, registering gets you your constructive use date nationwide, which is important if, for whatever reason, if you only have established common law local rights. Second, we recommend our clients investigate to make sure they have priority of rights. This is so crucially important because you want to make sure before you take any steps to enforce your rights that you actually have those rights. Well, our next step is recommending sending a cease and desist letter to the infringer. You don't want to do that if they've been using the mark a lot longer than you and your rights are less than what you thought. So once you find out that you do have priority of rights, we recommend that our clients send a cease and desist letter to the infringer, which hopefully will stop the activity. One thing to be aware of is that if your infringer is in another state, they could initiate a legal action to try to invalidate your trademark in their state, which is not the end of the world. It could be less than ideal because it could cause travel costs, et cetera, but it's something to be aware of. If you're both in the same state, it's not as much of an issue. And the last two steps are filing opposition and cancellation proceedings at the Trademark Office and pursuing federal court infringement action. Both of these are last resorts, but ultimately great ways to enforce your trademark rights. And with that said, there's a few other methods of policing your rights, such as a brand or trademark policy. And Zcash is one example of that. They have some trademark guidelines on their website, and many brands do something like these. They don't necessarily have these terms, but example terms are that use of the marks should not mislead anyone, and this kind of bleeds into term 2, which is that you can't use the Zcash marks when you're distributing a modified version of software currency, of their software or currency. And this really gets to the heart of the presentation. Zcash has their trademark because they don't want somebody making a website under the Zcash name or a web post under the Zcash name saying this currency or token is Zcash and duping people, because that dilutes their brand, and they want to have people to have the strong association that when something says Zcash, it is the Zcash token or coin. Other terms, it says that you cannot use a logo to suggest affiliation, but you can use the logo or marks to participate in the Zcash community and provide the actual unmodified Zcash software. Another interesting thing that the Zcash has do, and we recommend this to clients in certain scenarios, is that they have a licensed mark and an exclusively reserved mark. And the licensed mark applies to all these terms that we just talked about on this slide, that they should not mislead, they cannot suggest affiliation, but you can use them in certain circumstances. The exclusively reserved mark is much more restrictive, and Zcash is probably more likely to police that mark in broader scenarios than outlined before. So we're going to outline a few key takeaways from this presentation as we wrap up. First, virtual currencies can be protected by trademarks. These trademarks can take various forms, as John discussed before. They can be names, numbers, letters, slogans. These are all great ways to protect a cryptocurrency brand. And as John said, runs on Ripple. This was applied for just last week. So this is really, trademarks in cryptocurrency are really taken off, and this is a very new field, but it's a very important field. The trademark type and selection is so important for later enforcement. And as we discussed before, we recommend that our clients come to us and have us review their potential marks to see if it's a distinctive mark or a suggestive mark. And that's really what you want to shoot for. And once you acquire your trademark, as we discussed, a trademark can police your brand's rights. And without trademark registration, your brand could become generic or registered by somebody else. So in conclusion, we have a few recommendations. As we've said, we can't state this enough. We recommend to our clients that they pick a suggestive or even better distinctive mark for their virtual currency. We also recommend that they perform a thorough trademark search to make sure that their name is in the clear before they file the trademark. And last, we recommend that they consult a trademark attorney, such as John and myself, to assist with this selection, searching, and ultimately registration of the mark to make sure that everything goes as planned. And with that, we're going to open it up to some questions. And I think we have we've already taken one, but we have a first question that came in via email. And the question is that many crypto/blockchain projects are choosing to move to and start in Switzerland. If someone has a good thought of a good brand name or crypto project idea, but hasn't incorporated any entity in Switzerland yet, are there any downsides to trademarking a name in the United States now? Is it best to wait until the project is quote unquote born or established and trademarked in Switzerland instead? And I think definitely one example of this is Ethereum, which is in Switzerland. I think that might be what the questioner is, one example of what the questioner is pointing to. But John, why don't you take this one?
Thank you, Josh. This is a really interesting question, and one that basically, due to time restrictions, we didn't cover. But trademarks are generally national-based, which is interesting because the internet and the cryptocurrency mark is international, everywhere. It's not limited by national lines. So you can file now with a great idea in the US based on intent to use. But if you're actually a Swiss-based company, one of the things to consider is to file in Switzerland. you would then be able, within 6 months of your Swiss filing, you could file in other countries, including the US and the European Union. And there is a mechanism in the World International Property Office, WIPO, to cover international trademarks by registering them there and designating countries where you can protect, and including the countries where you can protect under WIPO's international registration is the US, Europe, as well as a number of the countries in the Far East. So that is certainly an option. File early. You could file an early US intent to use application, or you can file directly in Switzerland and then proceed through the international filings with the priority claims to obtain your protection in the US. So it looks like we've got another question here. It says, with many blockchain implementations of currency being distributed, is there a question of who would own the trademark? And the question is, even if Bitcoin were trademarkable today, as we discussed, this particular owner didn't take the path of exclusive protection. They actually took the path of having the mark become a generic term. But if it was trademarkable today, who would be able to own it? And for that, Josh, could you answer that one?
Absolutely. I think the short answer is that it's likely the creator, with the caveat that the creator has used the trademark in connection with the offering of the virtual currency to others. This is really a novel legal question. We're sort of an anonymous company having trademark rights, but the mark Bitcoin, I think, would still be a name that is used by the creator of Bitcoin or a company that he formed to use it in commerce. And the trademark laws, as you saw, were pretty broad, and they don't necessarily limit the types of people or businesses to traditional businesses. So whatever the stake the creator of Bitcoin had in his business, he can make a decentralized currency, and trademark law isn't going to, in my opinion, punish him for that. So I think that if we had that time machine and we could go back and it was not ruled to be descriptive, that a non-anonymous Bitcoin owner that applied for this could have gotten a mark at that time. Looks like we have one last question here. I think we have a couple more, but we're running out of time, so this will be our last for today. And this question is, what do you recommend to a company that has a new blockchain currency technology but hasn't branded yet? And I think we would recommend that first you think about your entire brand strategy. What as a company do you want your currency's name, logos, trading symbols, or slogans to be? Do you want it to be all four? Think about all of those in conjunction and make sure that you have those distinctive or at least suggestive marks. As we discussed, Ripple just last week may have begun a trend of trademark its own runs on Ripple slogans, so it's good to really think of all your possible trademarks at the beginning so that you have a strategy going forward with your company. I wouldn't really be surprised to see other currencies or trading exchanges follow suit with more slogans. There's a lot of slogans that are out there, but not many that have been trademarked yet, and I think Ripple is really on the forefront of getting their IP rights. And once that strategy has been considered, we recommend contacting an attorney such as John or myself to start that trademark search and file as soon as possible to get that constructive use state in the United States, and if, as John mentioned earlier, possibly internationally.
Thank you, Josh. And with that, we'll conclude the webcast. I want to thank all of you for joining us today and engaging in sending us questions. If you have any additional questions after we're through here, here's our contact information. We would love to hear from you and help you protect your brands, and we look forward to having you join us for our next webcast. Have a great